The secret-laden halls of Windsor have weathered many storms, but few as consequential as the legal victory recently secured by the Duke of Edinburgh's advisors. As public attention remained fixed on the throne, Prince Edward was methodically strengthening his foothold, laying claim to resources King Charles has long considered his own. This is no mere sibling squabble. It is a sophisticated battle waged through contracts, trusts, and constitutional precedent. The dust has now settled, the agreements are binding, and the redistribution of royal influence cannot be undone. The quiet prince has made his move. Bagshot Park is far more than a grand Tudor Gothic residence sprawling across 51 acres. It is the cornerstone of Prince Edward's deliberate, decades-long plan for security. Persistent whispers within royal circles suggested that King Charles, driven by his ambition to reduce the monarchy's financial footprint, had been eyeing this prestigious Surrey property for absorption into either the Duchy of Lancaster or the broader Crown Estate portfolio. Yet the king's aggressive restructuring campaign, which had successfully pushed other royals aside, met an immovable obstacle the moment it turned toward the Duke of Edinburgh. Edward's imperviousness to this pressure traces back to a shrewd financial decision made roughly 20 years prior, one that Charles's own legal team has allegedly been compelled to acknowledge as watertight. Back in 2007, Edward made a bold and far-sighted gamble that would anchor his family's stability for generations. Rather than accepting the precarious grace and favor arrangements that left most royals entirely at the sitting monarch's mercy, his negotiators struck a far more advantageous deal. Edward paid a remarkable £5 million as a single upfront payment to the Crown Estate, locking in a lease stretching an extraordinary 150 years. This was no ordinary tenancy agreement. It was the strategic purchase of time itself. That hefty lump sum stripped the king of any practical leverage to remove Edward from the property or impose market-level rents. In return, Edward secured what is legally termed a peppercorn rent, a token annual payment so minimal it barely registers, effectively freezing his housing costs indefinitely while the estate's worth, now believed to exceed £30 million, climbs ever higher. This arrangement, which might be called the Covenant of Bagshot, has quietly simmered as a point of contention inside the palace's reform circles. By 2026, scrutiny had reached such a pitch that the Parliamentary Public Accounts Committee opened formal investigations into what critics describe as overly generous royal leasing terms, with the Edinburghs squarely in the crosshairs. Adding fuel to the fire, it emerged that the couple had been commercially subletting renovated stable buildings on the estate, generating approximately £130,000 annually. While opponents argue that revenue of this kind ought to benefit the public purse, Edward's legal representatives have confirmed that the original 2007 agreement explicitly authorized exactly this kind of commercial activity. Rather than being a tenant beholden to royal goodwill, Edward has effectively positioned himself as a property stakeholder operating within the king's own domain. What makes this arrangement even more remarkable is not simply its length, but the extraordinary freedoms it contains. The Prince and Princess of Wales, by contrast, hold a 20-year non-transferable lease on Forest Lodge priced at full market value, terms that keep them firmly under the Crown's thumb. Edward's lease, however, is assignable, meaning his legal team has confirmed he possesses the genuine right to sell the leasehold on the open market should he choose. He is not merely a resident. He is the holder of a multi-million-pound legal interest that the king cannot dissolve without either a protracted court battle or a financial buyout the Crown Estate has shown no appetite to pursue. As Charles attempts to draw royal assets under tighter central control, he is confronting the uncomfortable truth that his most understated brother was also his most legally sophisticated. Rather than waiting for a change of reign to negotiate his position, Edward spent the early 2000s constructing a legal architecture robust enough to outlast the transition from his mother to his brother. The legal confirmation from his council is therefore about something far greater than bricks and mortar. It is proof that Edward holds a stake in the monarchy's future that lies entirely beyond the king's grasp. That reality has quietly but fundamentally reordered the family's internal hierarchy, transforming Edward from a peripheral working royal into an entrenched and legally untouchable presence in British life. But property, significant as it is, represents only one dimension of this contest. The deeper struggle is inscribed in the language of hereditary titles. The contest over the Duke of Edinburgh title was never really about prestige alone. It was a protracted legal confrontation pitting a father's expressed wishes against a sovereign's constitutional authority. When Prince Philip wed the then Princess Elizabeth in 1947, his Dukedom of Edinburgh came with a standard hereditary clause directing the title to pass to his eldest male heir, Charles, upon Philip's death. Yet in 1999, a highly unusual and very public commitment was made. The palace formally declared it to be the joint wish of both the Queen and Prince Philip that the title would ultimately be bestowed upon Edward. Far from being an emotional gesture, this declaration functioned as a structural pledge, one that Edward's legal advisors have spent years positioning as legally enforceable against any future monarch inclined to disregard it. Following Prince Philip's passing in 2021, matters came to a head. Strict peerage law dictated that the title merged automatically with Charles's accumulated dignities, and upon his accession in 2022, the Dukedom of Edinburgh effectively ceased to exist as a separate entity, reverting entirely to the crown. In that moment, the king appeared to hold complete control. Reports began filtering out from the palace that Charles, anchored to his vision of a leaner royal institution, was weighing whether to honor the 1999 commitment at all. Speculation suggested he might preserve the title for Princess Charlotte, or alternatively avoid creating additional hereditary dukedoms that could complicate succession arrangements. It was at precisely this juncture that Edward's legal counsel is said to have intervened decisively, placing before the king's advisors the argument that the 1999 public declaration had generated a legitimate expectation, a meaningful and enforceable concept under British constitutional and administrative law that could not simply be set aside. What followed was a carefully negotiated settlement, concluded on Edward's 59th birthday in March 2023. Edward did receive the dukedom, but attached to it was a significant legal qualification. The title was conferred as a life peerage rather than a hereditary one. This distinction is virtually without precedent in the history of royal dukedoms, which have traditionally descended from father to son. By structuring it as a life peerage, the king's lawyers ensured that Edward's enjoyment of the title would be personal and non-transferable. It would not flow to his son James, and upon Edward's death it would revert once more to the crown. Even so, Edward's team extracted meaningful concessions within this framework. Accepting the life peerage cleared the path for the Edinburghs to remain firmly embedded in the working royal establishment at a time when other family branches were being quietly marginalized. Crucially, the specific terms of the grant, despite its non-hereditary nature, formally entrenched Edward's standing as a senior councillor of state, endowing him with constitutional authority to discharge royal duties in the king's absence or during periods of incapacity. What appeared from the outside as a brotherly act of generosity was in fact a negotiated settlement. Charles preserved the integrity of the hereditary peerage system, while Edward secured both the title his parents had always intended for him and the institutional standing to ensure he could never be shuffled to the margins of the royal enterprise. The significance of this outcome extends well beyond a single title. By insisting on and ultimately receiving the dukedom, even in modified form, Edward delivered a clear signal that the king's program of centralization has boundaries. The 2023 letters patent carry a meaning that transcends their formal purpose. They are an official acknowledgement that even a sovereign committed to institutional reform must yield when confronted by a documented promise and a legal team prepared to enforce it. Understanding why this result carries such weight requires examining the remarkable private fortune that Prince Philip left in his wake. Beneath the monarchy's ceremonial exterior lies a private financial world of considerable complexity and scale. King Charles has long positioned himself as the primary custodian of royal resources, but a significant legal development in early 2026 has upended that assumption. Evidence has emerged suggesting that Prince Philip quietly constructed what amounts to a shadow trust, a private legal vehicle established during his lifetime with the specific purpose of channeling a meaningful portion of his personal fortune directly to Edward, bypassing the king's control entirely. This wealth bears no relationship to state funds or duchy revenues. It represents the independently accumulated assets of a man who dedicated 73 years to the institution, and whose final financial arrangements are now being methodically unraveled by a specialist legal team. The mechanism that has kept these matters private is the long-standing British practice of sealing the wills of senior royals, a convention designed to shield the constitutional standing of the crown. Such documents remain out of public reach for 9 decades. Prince Philip's will, held under secure custody by the President of the Family Division of the High Court, is subject to this same restriction. Sealing, however, does not suspend the will's operation. It merely prevents public scrutiny of its contents. Since 2021, executors have been quietly working to administer an estate that some financial analysts estimate at upwards of £30 million, encompassing fine art, rare bibliographic collections, and various private investment holdings. The reverberations now felt within the royal family trace back to a 2026 legal confirmation in which Edward's advisors successfully established his entitlement to particular assets that Charles had long treated as belonging to the Central Royal Collection. According to palace sources, these assets encompass privately acquired equities and land interests that Philip accumulated entirely independently of crown structures. Where the king had categorized these holdings as institutional resources falling under the reigning monarch's stewardship, Edward's legal team produced documentation of an inter vivos trust, a legal arrangement activated during Philip's own lifetime, explicitly designed to ensure that his private estate would reach Edward directly, free from any consolidation agenda imposed by a future reign. This legal maneuver strikes at the foundation of Charles's centralization ambitions. The king entered 2026 intent on pooling all available royal resources under unified authority to reduce taxpayer exposure. Edward's successful assertion of his inheritance rights has punched a significant hole in that strategy, carving out an independent financial base for his family that sits entirely beyond the reach of the king's reviews. The reaction within Clarence House has reportedly been one of considerable surprise. The depth and sophistication of the legal protections Philip put in place for Edward evidently exceeded what the king's advisors had anticipated. The inference is that Philip, foreseeing the vulnerabilities his youngest son might face under a different sovereign's reign, worked methodically with experienced solicitors in his final years to guarantee that Edward would never find himself financially subject to royal whim. The resulting trust structure is designed to sustain the Edinburgh family's way of life, their philanthropic commitments, and their independence across multiple future generations. The scope of this inheritance reaches beyond financial assets. Edward now holds legal control over Prince Philip's personal documentary archive, an extensive collection of private correspondence, diaries, and papers accumulated over a lifetime. Within the monarchy, the ability to shape historical narrative carries its own form of power. By controlling access to these materials, Edward's team has effectively secured influence over how Philip's legacy is constructed and presented, and by extension, how the late Queen's private story is told. The crown may rest on Charles's head, but the keys to the family's private historical record now belong to Edward, a shift that has materially altered the internal dynamics of the House of Windsor. This inheritance confirmation sends a pointed message to the king. The private family and the public institution are not interchangeable, and the laws governing trusts and probate protect one from the other. Charles retains authority over the apparatus of the state, but he cannot direct the flow of privately held family wealth when it has been insulated by careful legal planning. The brother, once regarded as the least consequential of the three, has demonstrated a degree of financial and legal foresight that has left the king with considerably less room to maneuver than he had assumed. Royal narratives have long cast the younger sibling as a figure of frustration or irrelevance, the one destined to orbit without purpose. Edward, however, has entirely rewritten that story. While Charles spent his extended tenure as heir navigating the thorny terrain of the Duchy of Cornwall and enduring sustained public scrutiny of his private affairs, Edward was cultivating something less visible but ultimately more durable, a reputation for what those close to the palace describe as inner steel, a composed, legally grounded professionalism that has quietly made him the monarchy's most dependable pillar. The revelation that has unsettled the royal family in 2026 is not merely about the assets Edward has protected. It is about the dawning recognition that the brother everyone overlooked has, in purely technical and legal terms, run circles around the sovereign's own reform agenda. At the root of this divergence lies a fundamental difference in philosophy. Charles has directed his energies toward the state, the taxpayer-accountable, publicly visible machinery of the crown, which must constantly justify its existence to a skeptical modern audience. Edward, by contrast, has invested in the family, the private legal infrastructure that keeps the Windsor name relevant and financially secure regardless of the political weather. This distinction gained constitutional force when the 2022 amendments to the Regency Acts formally designated Edward and Princess and as permanent councillors of state. As the king found himself compelled to distance the institution from both Prince Andrew and Prince Harry, each damaged by their own circumstances, Edward's unblemished record elevated him to the role of principal royal deputy, filling the operational void left as Charles and William have each navigated serious personal and health challenges. His position as Councillor of State is anything but ceremonial. Since he and Sophie committed fully to royal duties in 2002, Edward has maintained one of the most demanding public engagement schedules in the family, completing nearly 300 official engagements in 2023, surpassed only by the king himself and Princess Anne. That sustained commitment has generated a form of institutional credibility that proved decisive when the king's advisors assessed the royal family's capacity in early 2026. Edward's branch was judged the only one stable enough to absorb responsibility for the newly released Philip Trust assets and the commercial management of Bagshot Park without attracting legal challenge or damaging public attention. The inheritance confirmation has also served as a protective shield for the generation below. While the king has moved to curtail the titles and financial standing of various non-working family members, Edward's legal maneuvering has embedded Lady Louise and James within the private wealth structures in ways that will serve them for decades. The absence of royal titles from their names belies a financial security that surpasses that of many higher-ranking members of the family. This encapsulates the essential contrast between the two brothers. Charles is working to preserve the institution of the crown, while Edward has quietly and effectively preserved the Windsor family itself. By 2026, the power map looks markedly different from what Charles had envisioned. He remains sovereign over the United Kingdom, but his youngest brother has emerged as sovereign over the family's private domain. This has produced the paradoxical situation where the king must now effectively enter into negotiation with a sibling over resource access and the allocation of royal duties. Edward has long since ceased to be the understudy awaiting direction. He has become the operational steward of the family's most critical legal and financial interests, a role both confirmed by his lawyers and made necessary by the very reforms Charles set in motion. And ultimately, this is about more than money. It is about what kind of institution the House of Windsor will be in the decades ahead. Legal victories of this complexity are rarely won by contracts alone. They require a parallel mastery of narrative and perception. While Prince Edward's solicitors constructed the technical scaffolding of his various claims, those close to the palace consistently point to Sophie, the Duchess of Edinburgh, as the strategic intelligence behind the couple's most consequential wins. Her professional formation in public relations. She co-founded her own consultancy, RJH Public Relations, before transitioning into full-time royal life, has proved to be an asset of remarkable value in an institution where image and reality must always be carefully choreographed. In the turbulent 2026 environment of royal reorganization, it was reportedly Sophie's precise reading of media dynamics and reputational risk that gave the king's camp serious pause before pressing ahead with its more aggressive cost-cutting measures. Sophie's leverage flows from a foundation that is both personal and strategically significant. She was widely regarded as the late Queen Elizabeth's closest confidant among the younger generation of royals, a relationship informally described as that of a second daughter. This was never merely sentimental. It manifested in concrete acts of institutional support throughout the Queen's reign. As early as 2002, the Queen made the unusual decision to permit Sophie to occupy Buckingham Palace grounds prior to the marriage itself, and subsequently secured the Edinburgh's long-term base at Bagshot Park when Sophie's business closed. By 2026, Sophie's legal advisors have reportedly drawn on this documented history of royal favor to advance the argument that the late Queen's intention was always for the Edinburghs to remain permanent, well-resourced participants in the working monarchy, an argument that carries genuine legal and moral weight. Her instincts have been particularly sharp in managing the optics of the title dispute. The king may have been inclined toward a narrower reading of the inheritance commitment, but Sophie grasped something Charles's advisors appear to have underestimated. The British public, and the Windsor brand more broadly, understood the Duke of Edinburgh title as a sacred obligation honoring the late Queen's express wishes. Sophie's team successfully reframed the entire legal proceeding, not as Edward pressing a personal claim, but as the family honoring a mother's final wish. In an environment where Charles remains acutely sensitive to public approval, that reframing created a political reality in which refusing Edward became essentially untenable. Her advocacy has extended to commercial matters as well. Sophie's work across more than 70 charitable causes, with particular dedication to women's rights, conflict resolution, and disability inclusion, has made her arguably the most positively regarded member of the working royal family. That reservoir of public goodwill has translated into negotiating leverage. When the king's advisors floated proposals to claw back commercial revenues from Bagshot Park, it was reportedly Sophie's team that effectively neutralized the idea by highlighting the reputational damage that would flow from penalizing the royal family's most industrious humanitarian. Sophie represents the essential connective tissue between Edward's legal victories and their public sustainability. She has transformed his characteristically low-key manner into a strategic advantage, providing the public voice, professional credibility, and media fluency that his legal team alone could never supply. By the time the 2026 agreements were finalized, her contribution was unmistakable. She had not merely supported Edward through the process, she had professionalized his entire defense. The Edinburghs have demonstrated that, in the contemporary monarchy, the most durable inheritance is one that can withstand challenge both in court and in the court of public opinion. The legal architecture is now in place. The map of royal assets has been redrawn in ways that cannot easily be reversed. The central conflict animating the 2026 royal landscape is a collision between two fundamentally incompatible visions of how the monarchy's enormous financial holdings should be managed. King Charles III has been the most consistent and vocal champion of a rationalized, leaner institution, a crown that can demonstrate fiscal responsibility in an age of heightened public accountability. His strategy rested on concentrating the principal revenue streams, the sovereign grant, the Duchy of Lancaster, and the Crown Estate, under more coherent centralized oversight. The legal confirmation of Edward's inheritance rights has torn a significant opening in that plan, confronting the king with a dilemma that is simultaneously a financial problem and a family one. The king had designed his 2026 agenda around the expectation that as grace and favor properties gradually became available, they would revert to the Duchy of Lancaster and bolster the privy purse. The duchy, which returned over £28.7 million in 2024-25, is Charles's primary private income source. Drawing Bagshot Park and comparable estates back under duchy management would have significantly strengthened the Crown's capacity to sustain the working monarchy without leaning so heavily on the sovereign grant, itself forecast to reach nearly £138 million by 2027. That calculation was derailed when Edward's lawyers established, beyond meaningful dispute, that the 150-year lease and the Philip Trust arrangements place his assets in an entirely separate legal category, one the Crown Estate Act 2025 reinforces as a binding commercial contract immune to unilateral sovereign termination. The king has managed to relocate or otherwise pressure other family members. Prince Andrew, for instance, was relocated from Royal Lodge to more modest Sandringham accommodation in early 2026, but Edward has proven a categorically different proposition, and the Crown has been forced to accept him as what amounts to a permanent, self-governing presence within its own estate. Beyond the financial dimension, this failure carries a deeper institutional cost. Inside the palace, Edward's successful resistance has begun to function as a reference point, a demonstration that the king's program can be challenged and contained through determined legal action. If the Duke of Edinburgh can construct an impenetrable legal shield around his lifestyle and assets, others may be emboldened to attempt the same, gradually eroding Charles's authority to impose consistent standards across the family. This dynamic is rendered more acute by the fact that Edward and Sophie are presently among the king's most indispensable working allies. Any move to escalate the legal contest would risk undermining the very partnership that keeps the monarchy's public obligations functioning at a time when the active royal roster is already stretched thin. The Edward episode has also thrown into sharp relief a fundamental conceptual disagreement about the nature of royal property. Charles treats the estates as instruments of state, institutional resources to be managed in the public interest and directed by the reigning sovereign. Edward's lawyers have successfully argued the opposite, that these are family assets, governed by the same property law available to any private citizen, and shielded accordingly. That framing has insulated an entire branch of the family from the king's financial reorganization, effectively creating a two-speed Windsor family: those subject to the sovereign's fiscal authority, and those who have built their own legal perimeter. By the middle of 2026, the shape of the problem is unmistakable. Charles holds the throne, but not unconditional dominion over the family's wealth. Edward's legal victories function as a constitutional check, a reminder that even monarchs must operate within the boundaries of contract law and private trust. As the king continues his drive toward a more streamlined institution, he must proceed with the knowledge that a permanently protected enclave exists within it, one his own legal advisors have confirmed lies beyond his reach. The monarchy presents a united face to the world, but the documentary record tells a more complicated story. The opening months of 2026 have brought the British monarchy to an inflection point, and the figure who has most visibly consolidated his position through this period of uncertainty is not the heir to the throne but the Duke of Edinburgh. As concerns about King Charles's health have prompted the institution to enter what those close to the palace call a precautionary phase, the legal fortifications Edward has systematically put in place have elevated him from a background figure to a central pillar of the working regime. The initial disruption caused by his legal maneuvers has given way to a settled new reality. While William and Catherine prepare for an eventual succession, it is Edward who provides the legal and operational continuity the current monarchy depends upon day to day. The working royal landscape of 2026 is defined by absence. The king's treatment regimen has reportedly taken a physical toll that limits his participation in demanding state functions. Prince Harry and Prince Andrew have each been absent from official duties for their own reasons. The effective councillors of state, those with both the legal standing and the public credibility to carry the institution, have contracted to a small inner circle of Queen Camilla, Prince William, Princess Anne and Edward. Unlike the heir apparent, who must dedicate considerable attention to preparing for the responsibilities of kingship, Edward has stepped into the role of day-to-day operational manager for the crown. He now holds stewardship of more than 70 patronages and military colonelcies, filling a gap in institutional continuity that no one else within the family has the standing or the bandwidth to address, a gap strikingly similar to the one left by Prince Philip's death. The authority underpinning this role is not merely practical, it is constitutional. The Councillors of State Act 2022 granted Edward permanent powers to execute routine state documents, participate in Privy Council proceedings, and formally receive diplomatic representatives, functions that have assumed increasing operational importance as the king's public calendar is managed with greater care. While the spotlight falls on William and Catherine as they take on more visible monarchical responsibilities, Edward has quietly taken charge of the institutional machinery that keeps the crown running behind the scenes. His legal team has confirmed that the combination of his lifelong Councillor of State status, the security of his Bagshot Park tenure, and his control over the Philip Trust portfolio makes him the single most legally fortified member of the family. The cumulative result of these developments constitutes a genuine transformation in the royal power structure. Edward no longer occupies a peripheral position within the firm. He functions as a senior executive whose interests are protected by an interlocking network of legal instruments that royal reform cannot dislodge. His public approval, with over half the British population holding a positive view of him, provides the soft power to complement his hard legal standing. As 2026 progresses, the signal from the Duke of Edinburgh's legal counsel carries unmistakable force. The monarchy is undergoing contraction, and the succession is being prepared, but Prince Edward's position in the present and future history of the House of Windsor has been secured with a permanence that no subsequent political change is likely to undo.